Hello, I'm Greg Boyd, partner in the corporate team of Harneys in the British Virgin Islands. I'm joined today by team member George Weston.
Hello. Today we're going to talk to you about the duties of a director of a British Virgin Islands business company, the consequences that can flow from a breach of duty, and some steps that can be taken to mitigate against the risks. Before we discuss the duties themselves, we need to first consider the question of who is and who can be a director under BVI law. All BVI business companies are required to have at least one director, although that director does not have to be a natural person and could, for example, be a company or corporation. There is no nationality requirement to the BVI, so directors do not have to be BVI residents or citizens, and a corporate director could be a foreign company. The BCA contains a statutory definition of director, which includes a person occupying or acting in the position of a director by whatever name called. This means the person could still be liable for breach of duty even if he was not properly appointed, for example because of some procedural defect in his appointment, or simply because no thought was given to the nature of his role.
The principal statutory duties of a director can be summarised as follows. The best interest duty. This is the duty to act honestly and in good faith and in what the director believes to be is in the best interest of the company when exercising his powers as a director. The next duty is the duty of skill. This is the duty to exercise the reasonable care, diligence and skill that a reasonable director would exercise in the same circumstances, taking into account, but without limitation, the nature of the company, the nature of the decision, and the position of the director and the nature of his responsibilities. The proper purpose duty. This is the duty to exercise his duties for the proper purpose and in accordance with the BCA and the Memorandum and Articles of Association of the company. Finally, there is the disclosure duty. This is the duty of a director to disclose any interest which he has in a transaction entered into or to be entered into by the company.
The duty to act in the best interest of the company is a subjective test which goes to the motivation of the director himself. A decision made by the director in the honest belief it is the best course of action will not breach the duty, even if the decision turns out to be a poor one. In practical terms, however, the worse the decision, the harder it will be for the director to argue it was entered into in good faith. There are three very helpful potential modifications to the duty to act in the best interest of the company that can apply where an express provision to that effect is made in the Memorandum or Articles of Association of the company. First, the director of a wholly owned subsidiary company may act in a manner which he believes is in the best interests of the company's holding company, even though it may not be in the best interests of the underlying company. Second, the director of a company that is a subsidiary but not a wholly owned subsidiary may, with the prior agreement of the shareholders other than its holding company, i.e. with the agreement of the minority shareholders, act in a manner which he believes is in the best interest of the company's holding company, even though it may not be in the best interest of the company of which he is a director or the minority shareholders. Thirdly, a director of a joint venture company may act in a manner which he believes is in the best interest of a joint venture party, usually the party appointing him, even though it may not be in the best interests of the company.
The reasonable skill duty is an objective test which goes to how a hypothetical director would have acted in the same situation as the director and effectively sets a minimum standard of care. Board papers and minutes which clearly show the rationale for the decision and the factors considered by the directors can all be helpful in demonstrating that the duty was satisfied. Courts have traditionally been reluctant to second-guess commercial decisions. Although the BCA does not refer to the actual level of skill, knowledge and experience of the director, there is a long-established common law principle that a director with a particular knowledge and experience may be held to a higher standard. So, for example, a director with legal background or an accounting background might be expected to have thought more carefully about legal or accounting risk. Equally, a director that lacks expertise in relation to a decision that must be considered might be expected to obtain external professional guidance. The BCA does not specify the meaning of proper purpose, and although the term is derived from a fiduciary concept on which there is substantial case law, there is no established definition. In essence, the concept of acting for proper purpose requires that a power or discretion is exercised for the reason which that power or discretion was granted. In practice, any corporate action that is for a legitimate commercial purpose, which is lawful and a foreseeable use of a power of the company, should not fall foul of the duty. it might be helpful to consider an example. Issuing shares for the purpose of raising capital is a proper purpose, but issuing shares to dilute the voting power of shareholders who wish to replace the board members is not. The proper purpose duty also requires compliance with the BCA and the Memorandum and Articles of Association of the company, essentially giving both the statute and the constitutional documents teeth by making the directors duty-bound to comply with them. Clearly, it is important for directors to understand the requirements of the Memorandum and Articles of Association and their legal obligations generally, and to seek legal advice where in doubt. The BCA makes clear that a director is not generally personally liable for any debt, obligation, or default of the company. However, there may be personal liability for the directors where they or the company have exceeded their powers or there has been a breach of duty or negligence by them. With the exception of the failure to disclose an interested transaction, which carries a fine of $10,000 on summary conviction, the consequences of a breach of duty have not been set out in the BCA, but presumably follow the common law position, where damages have been calculated on a tortious basis. In other words, based on putting the company in the position it would have been in had the breach not occurred. This could include paying compensation for losses, returning any property belonging to the company, and paying the company any profit improperly made by the director. The duties of directors are principally owed to the company itself, and not to its shareholders or creditors, and as such, the proper claimant in such an action should usually be the company itself. The BCA contains detailed provisions setting out where a derivative action, an action that can be brought by a shareholder on behalf of the company, may be brought, but that is beyond the scope of today's discussion. It should also be noted that in a situation where a company is insolvent or is likely to become insolvent, then the directors will owe their duties to the company with reference to the general body of creditors, rather than to the shareholders. A range of director and officer policies are commercially available to help protect directors from personal liability, including for breach of duty. Such policies are expressly permitted under the BCA. As with all insurance policies, D&O policies are invariably subject to a number of exceptions and limits, which the directors should consider carefully. In particular, most policies will not pay out where the director has been grossly negligent or acted in bad faith. As such, they should not be regarded as a complete shield to liability. Interestingly, the BCA permits insurance coverage to have a broader scope than indemnification by the company, but that does not mean that such coverage will be available in the marketplace. Thank you for taking time today to learn more about the duties of directors of BVI business companies. We hope this presentation has been helpful to you.
If you have any questions about any of the matters discussed in our presentation today, or if you have any further questions about directors' duties more generally, please feel free to contact Greg, I, or any other member of the corporate and commercial team here at Harneys.